Hello and welcome back to part 11 of our video series on intellectual property law and legal English's impact in it. Part 11 is where we're going to talk about what types of things can be copywritten. As you've probably figured out by now, not everything. Patents are the world of inventions. Trademarks are the world of logos. And copywritten materials are the world of creativity. But first, that's me. My name is Jeff Keiser. I've been a lawyer for a long time now, but I really love my work with legal English and being an educator for people like you. I have worked with people at all levels from dozens of countries, and I've absolutely enjoyed every second of it. I believe that by spreading legal English, it gives us all a chance to communicate on the same level. And while I wish I was a fantastic polyglot that understood dozens of languages, the reality is many large businesses operate in English, and the law is no different. So thank you for spending the time with me, and I look forward to spending a little bit more with you. So, only a few things can obtain copyright. And there's more every day, really. Literary works, musical works, dramatic works. The music for a musical or a dramatic work is usually separate. A dance routine, a choreographic performance can be copywritten. All of the arts, painting, drawing, sculptures, absolutely. Movies and sound recordings. And yes, architecture can be copywritten. They check all the boxes and they fall squarely within that. So if you see a house you like or a building you like, you can't just copy it and call it your own. It doesn't work that way. So I think the best way to look at this is to compare these different things. A copyright will protect original works of authorship, like books, articles, songs, photographs, and more. Whereas a trademark protects words, phrases, symbols, and or designs that identifies and distinguishes the source of the goods. It's the logo. It's the Coca-Cola font. But other things cannot get a copyright as well. Ideas and concepts. You can't say that I have the idea to write the best book of all time and have it be copywritten. You have to actually write the book. Similarly, things like procedures and processes are open to the world. Systems and methods of operations cannot be copywritten. That's more in the world of a patent, right? I think it's interesting to think that you cannot patent a name or copyright a name or a title. It can't be done. Nor can you copyright a short phrase. I find that interesting. Think of it this way. Copyright protects the expression of the idea, but not the idea itself. It's designed to protect art and creativity, not the ideas behind that creativity. So, in theory, someone else could write a book about a boy wizard. And while copyright protects J.K. Rowling's specific telling of the story, she can't copyright that idea in its more general sense. U.S. copyright law, the Copyright Act, at least that's easy to understand, expresses the principle against the ability to copyright procedures and processes. It states that in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. Inventions are the subject matter of patents, not copyrights. Just because we can't copyright everything doesn't mean that it's an easy thing to license or share that copyright. A licensing agreement is the contract that gets you there. The two parties are typically known as a licensor and a licensee, and typically the licensor grants the licensee the right to produce or sell goods, apply a brand name, or use patented technology. It's simply a temporary transfer of the copyright or other intellectual property right. Licenses operate in every industry, and I've written several contracts myself that allow it. They're fun to write because it's a fun subject matter, but to get them right is really technical. Next time on intellectual property, we're going to talk about copyright infringement, what that means, and what someone can do to prevent it from happening in the future. And this is really the point of intellectual property law at all, is to stop somebody from infringing upon it. See you then.